Before I introduce the panel, I'd just like to say a few words about some of the related issues to copying images. First of all, my name's David Wood. I represent, one of my clients is an industry association called ICOMP, the Initiative for a Competitive Online Marketplace. CEPIC is a member of that, has been a member. For many years, Sylvie has been your representative there. We were set up nearly 6 years ago to look at online issues, to try and understand them better, put together people from different parts of the ecosystem, publishers, technology companies, advertisers, content owners. And we needed to understand what was going on so we could inform stakeholders, governments, the European Commission, politicians, the press and so on, so that these incredibly important issues would be understood, would be heard, and would be explained to a broader audience. An example of the kind of thing we've been doing, I think, was in your packs when you arrived, or you can get one of our papers, is called Profiting from Free, the Scourge of Online Piracy and how industry can help. That's an example of one of our papers. There are many more on the ICOMP website. We're also a formal complainant in the ongoing antitrust investigation into Google's behaviour that's being conducted by the European Commission. I think Michael on the panel will talk a bit more about that complaint. So there are a number of different strands that go to make up the story at the moment. There's the antitrust case. That's not a done deal in Brussels. That's going to come to a head over the next few months. It's possible that action will be taken, significant enforcement action will be taken against Google. It's by no means certain. It's important that people from all four corners of the European Union make their views known to their members of parliament, to their politicians, and to their representatives in Brussels. There are the intellectual property issues, not just copyright, but trademarks, patents as well. There are data protection issues, the right to be forgotten that I'm sure you've heard about over the last few weeks. These are all separate strands. These legal cases are different, but they point in the same direction. There is a relationship between them. And that relationship is that it's difficult to compete with somebody who takes other people's content for free. It's difficult to compete in markets where there's a single player whose dominance is built on the unlawful acquisition of other people's things, whether it's intellectual property or data or Google moving into other people's marketplaces. It does beg the question, I think, that this panel may actually start to think about. Is this an issue that can be dealt by, if you like, moral reasoning? Should industry be doing things other ways? Or do you need governments to step in, courts to step in, to regulate, to control behaviour? So today, we're going to talk a bit about what are the issues and about what is being done. We've got an hour and a half, I think. I've taken up 5 minutes already. We're going to keep the presentations relatively short so that there'll be time for questions. I do encourage you to ask questions. And so now I'm going to introduce the panel. On the far right, there's Thomas HÖPPNER, who's a lawyer for a firm called Olswang in Germany. He's a specialist in competition law and has drafted the complaints to the European Commission, both on behalf of the German publishers and separately on behalf of CEPIC. Then we have Michael Weber, who's the director of HOTMaps and the vice president of European Affairs for Eurocities, two mapping companies who have seen their enormous innovative efforts impeded by Google trying to squeeze them out of the market. We've got Professor Dr. Jan Bernd Noorderman, lawyer at Boehmart & Boehmart, also a specialist in the field of antitrust, who's the lawyer for one of the complainants in Brussels, Eurocities. We have Dirk Feldman, representative who's a lawyer in Hamburg, represents Freelance, and is a specialist in the field of copyright and competition law, and has filed a copyright complaint against Google in Germany, I believe. And moving on to my left, we have Kathy Aaron of PACA, who is in charge of digital image licensing in the US, and will give us a US view on many of these issues. And then finally, someone that needs no introduction, Sylvie Fodor. So I'm not going to say more than that, Sylvie. We're going to start with Sylvie. We were going to start with Michael Schilling, who's a photographer, who's going to present a video he's made, but unfortunately he couldn't be here for personal reasons. So Sylvie's going to step into his role and also present what he would have presented, but in his place. Thank you, Sylvie.
So, my name is Sylvie Fodor. So this is very unfortunate that Michael Schilling is not among us today, because he's the photographer who brought the attention of the issues of Google Images early 2013 to many people in Germany, including myself. I never met him, but we had extensive conversations on the telephone. So unfortunately, he could not be here today, but he sent his speech. It had been handed out, translated in English and handed out. So if you can still have one from the hostess at the door if you don't have it. And I will try to present his point of view also through my presentation. We will also start with his video, which attracted the attention of many people on this. So, unfortunately, the video, for non-German speaking people, please, the video is only in German, but I think pictures speak for themselves, so non-German speaking people will probably understand very well. And anyway, I will come back afterwards with my own presentation on the video and its content. Thank you.
Würdest du noch eine Webseite aufrufen, wenn du den Artikel in voller Länge bereits auf Google lesen könntest? Wohl kaum. Du hast ja dann bereits alles gelesen, was es auf der Webseite zu lesen gäbe. Doch exakt dies, nämlich vollständige Werke auf Google anzeigen, will die neue Bildersuche. Google posaunt heraus, tue nichts Böses, hält sich aber selbst nicht an diesen Grundsatz. Das beste Beispiel hierfür ist das sogenannte Redesign der Google-Bildersuche. Betrachten wir uns die Google-Bildersuche, wie wir sie bisher kennen. Google zeigt zu einem Suchbegriff passende Miniaturbilder an. Nach einem Klick auf eines dieser Suchergebnisse lädt die Webseite, in der das Bild eingebunden ist, in einem Frame, hier links zu sehen. Zusätzlich zeigt Google rechts weitere Informationen zum Bild an. Das war eine Lösung, die beiden, Google und den Betreibern von Webseiten, einen Nutzen brachte. Google durfte die Miniaturbilder anzeigen und brachte den Betreibern Besucher auf deren Webseiten. Nun zur neuen Bildersuche. Statt nach einem Klick auf ein Suchergebnis die eigentliche Webseite zu laden, zeigt Google das Bild in voller Größe in der Bildersuche an. Durch einen Rechtsklick auf das Bild lässt es sich problemlos speichern, in Originalgröße. Was für den Suchenden angenehm sein mag, ist für Betreiber von Webseiten wie ein Schlag ins Gesicht. Ein Besuch der eigentlichen Webseite, die das Bild enthält, wird überflüssig. Damit Google-Nutzer besser verstehen, weshalb sich Betreiber von Webseiten darüber aufregen, wenden wir dieses Vorgehen einmal auf die Websuche an. Google würde die Suchergebnisse wie gewohnt anzeigen. Ein Klick auf eines der Suchergebnisse würde jedoch nicht mehr zu der Webseite führen, auf der der Artikel veröffentlicht wurde. Stattdessen würde der vollständige Artikel auf Google zu lesen sein oder er würde per Sprachausgabe gar vorgelesen werden. Welchen Grund sollte jemand noch haben, die eigentliche Webseite aufzurufen, auf der exakt dieser Artikel zu sehen ist? Nur weil Inhalte im Internet größtenteils kostenlos zugänglich sind, bedeutet nicht, dass diese auch kostenlos erstellt und die Webseiten kostenlos betrieben werden können. Webseiten wie Blogs oder die Online-Auftritte von Zeitungen finanzieren sich durch Werbung. Weniger Besucher gleich weniger Einnahmen. Ein Besucherrückgang von 60% könnte bedeuten, dass sich etliche Webseiten nicht länger finanzieren lassen. Andere Seiten, auf denen Dienstleistungen im Vordergrund stehen, werden, ganz gleich ob die Versicherungsgesellschaft oder der kleine Handwerker, ebenfalls erhebliche finanzielle Einbußen erleiden. Potenzielle Kunden gelangen durch die neue Bildersuche gar nicht erst auf die Webseite des Anbieters. Es ist ein großer Irrglaube, alles, was im Internet kostenfrei zur Verfügung stehe, dürfe von jedermann kostenlos in eigene Webseiten verwendet werden. Im Internet veröffentlichte Inhalte sind kein Allgemeingut. Google, tue nichts Böses, ignoriert das Urheberrecht und tritt Kreative mit Füßen. Doch was wäre die Google-Bildersuche ohne Fotografen, ohne Zeichner und ohne Maler? Eine Google-Bildersuche ohne Bilder. Es ist jetzt die Zeit gekommen, um Google zu zeigen, dass wir Ersteller von Webinhalten keine rechtsfreien Sklaven eines milliardenschweren Konzerns sind. Da die neue Google-Bildersuche auch bereits in deutscher Sprache verfügbar ist es sonst nur eine Frage der Zeit, bis uns Google unsere eigenen Inhalte enteignet. Nein zur Content-Enteignung, nein zur neuen Bildersuche. Fassen wir noch einmal zusammen. Die neue Google-Bildersuche wird statt Miniaturbilder vollständige Werke anzeigen, nämlich Bilder in Originalauflösung. Die eigentliche Webseite, auf der das Bild eingebunden ist, wird nicht mehr geladen. Aus diesen Gründen protestieren wir gegen die Einführung der neuen Google-Bildersuche. Unterstütze uns mit deiner Unterschrift unter verteidigedeinbild.de.
Okay, I think you can hear me now. So you've seen two versions of Google Images in this video, but actually, at the moment, there are three. Well, maybe something changed yesterday, but at least yesterday there were three versions, because with Google it changes very often. Three different versions of Google Images, one which is available all over the world and in almost all languages in the world, also in German, as was mentioned in the video. Then you have one version which is available only in Germany, on PCs and on tablets and mobile phones. And you have a version which is available in France on PCs, but in France, if you go on your mobile phone, you will find the version that Michael Schilling has been criticizing in his video. So I'm going to go through these three versions to show you the difference and what our problem is. Let's search for the word auto, also auto in German, auto in French. We'll search in Germany, in France, and I took Austria, which is a German-speaking country, but the first result page will look approximately the same everywhere. Also when you scroll down. But the selected pictures will be very different after the second click. Here we are in Austria, as you can see, well maybe I don't know if you can see it very clearly, but as you can see on the browser, we are in Austria, and this is a version that Michael Schilling has been criticizing in his video. The photo appears large format and against a black background with no website behind. There's a possibility to scroll for similar pictures on the top, at the bottom, and on the side. It's very practical for mobile phones. The EXIF information has disappeared, and there's a hardly visible copyright notice at the bottom. Now, let's go to France. France has an intermediate version. As you see here, there is a large format picture in the front, but behind in the background, you can see the website where the picture is coming from. The website appears in the background. There is a clear copyright notice here in French. And the EXIF information is still available on the right-hand side. One click leads to the photo hosted by the website. In Germany, that's a version you now find on PCs and since December 2013 on mobile phones as well. Well, that's basically you see the website, you see the photo, and you see the website. It's very clearly the website where the photo is on the website. The EXIF information is still available on the right-hand side, and there's a clear copyright notice. Now, what's the consequences of the new version of Google Images? A lot of website owners noted that the fall of their traffic on the website afterwards. This statistics is the one we published in the first claim, which we to the European Commission. This is statistic we use. It comes from a respectable SEO company, right? And in a blog which is called "How the New Google Images Killed Image SEO." And as you see, for photo sites, there's a question of definition here. What is a photo site, of course? But the statistics here show a drop of 74%. There's another interesting consequence of Google, of the new Google images. These statistics were sent to me by a company based in Belgium, complaining about the new versions. And they complained because they said, you know, it's not normal. I'm in Belgium. I have this new version. We noted that there is a drop of traffic. You can see it here in the at the bottom, that's the Google, the referrals coming from Google Images.com, from Google.com in Belgium. But most of the traffic we receive now comes from France and from Germany, and we think that the French and German are in a better position. So he saw some kind of discrimination there. So that's an interesting, I think, consequence that there are 3 different versions of visual search engine. So to summarize, there's a diversion of traffic from websites. The new features encourage the free economy and piracy online, since there's no more link to the website. The picture appears against a black background, so the normal user will not necessarily know that it's things out there for free. You just need to right-click. In our claim from November 2013, we complain about the insufficiency of the exclusion robots. And then, of course, we see that Google is becoming the largest picture source in the world using third-party content. And all these issues are problematic, considering the market dominance of Google in search, well, it's 95% in Europe. The claim was lodged in Brussels in November 2013, and it's not just CEPIC alone. We lodged this claim. We've been supporting by a worldwide coalition in Europe and in the US. You see the list here. Altogether, 20 organizations. All the 6 national associations representing photographers and photo agencies in the US. We also have a collecting society for visual author in France who is supporting us. So all together, quite a representative coalition of the visual community. Thank you.
Thank you, Sylvie. Now it's going to be Thomas HÖPPNER.
Hello, my name is Thomas HÖPPNER. I'm representing CEPIC in its competition complaint against Google before the European Commission, as well as German press publishers in their complaint against Google. Thank you, Sylvie, for the invitation to speak about the competition law concerns about the new Google image search. When we think about Google's use of content, and in particular of images, of course, the first law that comes to mind is copyright law. And everyone is wondering, what has this to do with competition law? Because all we have learned is that if it comes to the remuneration and the use of content, this is a typical terrain of copyright law. Now, what we should not forget is that dominant companies with a dominant position on a particular market, are also subject to more strict rules under competition law. While every company is subject to copyright law, these dominant companies are subject to stricter obligations when it comes to their market conduct. That is because it is assumed that companies in a dominant position bear a special responsibility not to distort competition on their market. And because of that responsibility, they are banned from activities that may be allowed for everyone else and may even be common standard in that market. That is the reason why we assume that competition law has a very important role to play when it comes to dealing with Google. The main concern, of course, in this respect is that Google's use of third-party content, and in particular of images, may constitute an abuse of dominance. Because ultimately, Google uses third-party content to divert traffic from the sources that have created these products with high costs to its own websites, by just copying these images without bearing any own costs. So they are benefiting of third parties' investments to their own advantage. Already the American Federal Trade Commission, in its investigation of Google 2 years ago, figured out that this scraping of third-party content is anti-competitive, because such scraping, another word for copying, could diminish the incentives of the sources, the providers of those images, to invest in new images or in new content in general. And at the same time, it also reduces the incentives for Google to invest in such content, because Google can basically just copy third-party content without having to do anything itself. As a result of this investigation, Google committed itself to refrain from such scraping. Now, this investigation back then in the United States had nothing to do with images, because at that point the image industry had not complained about Google's use of images, but the general idea that scraping of third-party content can be anti-competitive and violate antitrust law applies here just the same. Similarly, the European Commission has also identified the use of third-party content as one of 4 concerns relating to Google in its current competition investigation. It finds that Google is using third-party content in its specialized search services and thereby promotes these services to the detriment of the websites where these pictures have been taken from. It all happens without authorization and sometimes even against the explicit will of the websites, who may have used some technical instruments to block Google, but which still appear in Google's website. Of particular concern in this respect is the link that Google has created between getting the right to display images for free and the visibility of the website that has published these images in the general web search. Basically, Google is blackmailing image providers, saying, if you don't give us your content, your images for free, and allow us to use it in every size and every form and every design we want to use it, then we will penalize you elsewhere, which is in the general web search in the ranking of your website, with the effect that your images will not be found anymore, but your competitors' images that have allowed us to use them widely within Google image search, they will appear first. So basically they are threatening the image providers with a competitive disadvantage towards their direct rivals if they don't play with Google and give Google the permission to use their images for free in every way Google likes it. As a result of this investigation, Almunia at least claimed that he has asked Google to sever this link, to break off this link, and to allow image providers to block off Google without having to fear that this will lead into some form of penalization elsewhere. And I must admit, though, that the result of this threat or request from Almunia is yet to be seen, because the proposed commitments so far contain no real remedy to this issue. As a result of that, CEPIC has decided to submit its own competition complaint, raising awareness for the fact that it's not just press publishers and other sites whose content is used by Google, but that's also image providers' websites that are the victims here. Now, why do we think that competition law is so crucial here? It has to do with this link that Google has created. The major weakness of copyright law in this respect is, even if you achieve to win a copyright law claim, Google can use its dominance, its monopoly in the end, to make you waive your rights. basically it's blackmailing you. If you don't waive your copyright and allow me to use your images for free without any compensation, and if you don't allow me to use it in full size and however I like it, then I will not display your website or your links or your images as good as I display other websites' images. And this penalty will be much more severe than the disadvantage you have from me using your images. And this threat that Google can create because of its monopoly in search is so strong that image providers and other content providers feel that they can't really risk to enforce their copyright law. A very good example of that is the German development in relation to press publishers' content. The German press publishers, as you may know, have fought for several years for a new ancillary copyright law for press publishers that protects their content against search engines and, of course, in particular against Google. Once they achieved this new law last August, Google stepped in and said, okay, well, if we fall under this law, which may be the case, may also not be the case, we argue it does not, then we now ask you, press publishers, to opt in our new, to opt in to Google News, basically to allow us to continue to use your content for free. If you don't allow us to use your content for free, we will delist you from the web search. So the threat was rather clear. If I don't waive this new copyright law, if I insist on a payment which the law wanted to provide for me, then Google will just simply take me out of the search results. And that, of course, has a far more significant detrimental effect. Another advantage of competition law in this respect is that you don't have to go through every member state's national court procedure, which would be in Europe. You have to go to 27 courts in 27 member states and then to the next level and to the highest court in that state because you want to enforce your rights. Rather, you can turn to the European Commission and enforce your right there. Reason being that in Europe there's a harmonized competition law. There's a particular European law on this issue, whereas copyright law has not been harmonized European-wide, so you would have to rely on national legislation. So we assume and we hope that the European Commission is in the best situation to remedy image providers' concerns effectively, and we encourage the Commission to take this issue seriously. And in the name of CEPIC, we would also encourage every support from you in this respect. Thank you very much.
Thank you, Tom. I know that Thomas has to go shortly, so while we still got him, does anybody have any questions for Thomas? Well, then because he's there, I'm going to ask him a question. Mr. Almunia, Vice President of the Commission, Commissioner Almunia, in charge of competition policy, has said, oh, all these issues, they're copyright issues. They're not things I can deal with. What's your response to that, Thomas?
We would say that he is wrong. He is, in fact, very wrong, because not just is it himself that had investigated and identified that there is an anti-competitive link, we actually think he has ignored some fundamental requirements under competition law. And one requirement is that you can't exploit your customers and consumers neither. And I think that is exactly what's happening here. Of course, Google is taking advantage of its own, well, customers in a way as well, because image providers feed Google services, and it's exploiting their investments to its own advantage. And of course, this has competition law implications, because it gives Google an anti-competitive advantage towards other search engines, aggregators, and so on and so forth, which can't blackmail image providers to provide all images for free with the threat, otherwise I will kick you out of the gatekeeper of the internet, which is the Google web search. So I think Almunia has to realize that Of course, this is not about remuneration directly, which is a copyright issue, but it's about making the foundation for copyright to work effectively, and that provides that Google can't come around the corner and say, well, you have your copyright, but I have my search engine. If you want your copyright, you're out of my search. And I think that is a fundamental competition law concern that has to be addressed.
And what remedy are you looking for? What are you asking Commissioner Almunia to do, Thomas?
I think there are several remedies that would be crucial. One is, I think, to accept a sophisticated rights expression language that would allow image providers to define in detail how Google and other aggregators can use their content, defining which size the images can be that are used, thumbnail, full size, high revenue, or just black and white. But it should be the image provider that can define that and determine the limits to the use of its products. That's the first requirement. And secondly, there has to be a guarantee that image providers that take advantage of these technical means, and I'm not just talking about this new rights expression language, but also talking about the existing robots exclusion protocol, that image providers that take advantage of these technical tools that are in existence are in no way penalized elsewhere, so that it has no detrimental effect whatsoever if an image provider stands up and is brave enough to say, you can't have my images for this service.
Thank you, Thomas. Very clear. Question there.
I was just going to add 2 more points to that as far as what we would like to see come out of it, which is a rollback to the German version, which is currently in place, so that one click on the image takes you straight to the underlying site, where you can see it in the context, where the site owner can benefit from that traffic and advertising revenue, and really has the opportunity to control it. And the other thing that we would like to see is better copyright information right up there where Google has currently buried it in text that is the same color as the background and in font that nobody can actually read. But to have Google really step up and make better representations about the material itself being protected by copyright.
Yes, that is, of course, very correct and very important. The whole trigger for the complaint was the new image design. So obviously that is our key requirement. Go back to your old design, because the new design is depriving us of all the traffic. Thank you for adding that.
I want to say that, as you mentioned, sorry for my voice, but today's speaking, the Spanish website is actually behaving like the German one. Not only in Germany, now in the Spanish website, when you go to search images in Google, and you click in the image and sends you to the original page, okay? So it's Google is not storing the images as they were doing before. So this is a positive outcome of this. The second thing I would like you to explain to the audience that in the Google answer to the CEPIC complaint, okay, he was saying, actually they were saying, yes, we're doing all this, but the others are doing exactly the same, okay? Well, I understand what the answer is going to be. I think it's better that you clarify to the audience.
Yeah, yes, I must admit that was a very lame excuse, and I was surprised to read that from Google, because obviously it's the core of this law on the abuse of dominance that only a dominant provider is under this particular responsibility and has to implement these rules, whereas non-dominant companies are not subject to this ban on the abuse of dominance. So obviously Google has to obey this law, whereas others can, if you like, ignore it. Plus there is a fundamental difference between Bing and Google. While you may afford to block out Bing because you think, well, it's just 5% of my traffic or so, you certainly can't afford to block out Google. And thirdly, I think we should keep in mind that Google, in many respects, is the one that sets the threshold. If Google releases this new designs, others have no choice but to follow, because obviously they want to keep up with their direct rivals. So if Google is expanding its image search, what else can they do than to adjust it? So I think to get this straight, it was Google that installed this new image design, and others followed suit because they had no other choice. But for them, it's not a competition law issue because they are not subject to the law on the abuse of dominance.
Thank you. Any other questions from the audience? No? Well, thank you very much, Thomas. I should say, in the interests of impartiality, that Google does, of course, claim that it has no market power and is not dominant on any relevant market, however implausible that argument is. Dirk Feldman.
Good afternoon. Thank you, CEPIC, and thank you, Sylvie, for the invitation to present our case here before this auditorium. My presentation is directly connected to what Michael Schilling and Mr. HÖPPNER told you, because we are leading a lawsuit against Google in relation to exactly these points. I'm representing since 1995 Photographers Union in Germany with about 2,500 members, and we are always trying to fight for the rights of the photographers and to reach verdicts by the highest courts in Germany that prove that copyright is still strong, not only in Germany but in Europe and all over the world. And what happened in 2013 was that not only Google but also Yahoo went a lot further than what we were shown by Michael Schilling in his presentation. He showed us what was seen on the computer screen. But in 2013, in summer or August it was, Yahoo and Google, they both presented pictures in their picture search on the smartphone screens in a way that I will describe to you now. First, as usual, when you went on the button looking for pictures, you would see the 12 or 16 pictures that would fit in the small size of this smartphone screen. But when you clicked one of these pictures, then you would only see the whole screen filled out with the photograph. No other information, nothing else. You could make another click and download this photo to your iPhone, and you could initiate a slideshow by swishing on the screen. And for example, you had a topic like auto or Michael Jackson or sports or whatever, then you could go on for hours and hours and had a slideshow of pictures filling this screen and showing these pictures with no information about the photographer, with no information about the website which produced these pictures, and only with more clicks the way to get there. So we said this is no search engine function, what they are doing. This is a way to present pictures, photographs, in a way that the photographer or the rights owner didn't give his okay to. So we thought what to do first. We picked the smaller player and we wrote to Yahoo, sent them a declaration of cease and desist to stop this. And within the time of some weeks, they agreed, they sent us this letter, they stopped it, and they even paid the lawyers' fees that I presented them. So this was a good start, and with this backup, we approached Google. And what happened was Google stopped this presentation at once. They didn't show it any further. We were happy that we had the screenshots to prove it, that they did it this way. And when we got their answer, they said, okay, we're not willing to do this anymore. We're thinking about another presentation, but we refuse to sign the declaration of cease and desist, and we refuse to pay the lawyers' fees. So that's what they meant is we want to still keep the right to present the photographs any way we want to, maybe the same way we did, maybe another way. And we thought this would be a good time to step in and to get a court decision which says, is it correct or is it not correct? So what we are trying to get from the Hamburg court now is a decision that says just what was mentioned. Must each search engine like Google go back to the German version or the Spanish version like we heard and present photos on screens, on smartphones and on PCs the way they did, and they do it now in Germany on PCs. If we can get this decision, I think this will be a very strong verdict that would stop not only search engines, but other users of photographs to use pictures and photographs without the permission of photographers. The question is, will we win? I'm quite sure that we win because we had a court meeting in March this year, and the judges pointed out that they will think about only one point. Is the showing of the full-size pictures on a smartphone screen, is this a search engine function? Does this make it easier to find the photo I'm looking for? Or is this a way to entertain people, to give the user more ways to use your iPhone and to have fun with it? If the last is what the court will accept, then we will win the case. And as we all know, smartphones are not only used for making telephone calls. In, I think, at least the same amount, they are used for taking pictures and looking at pictures and showing pictures to others. So what Google wanted to achieve with the way they were presenting the photographs was to give more entertainment to the user and not to enable him to find the pictures that he was looking for. Because one reason is they didn't give any more information with going with the picture. They only showed the picture and connected with the slideshow, so you could have pictures and look at pictures to one topic as long as you want to. And for this reason, I'm quite sure, I hope, that we will win this case and that it will be said by the German court, go back to the German version and stay there.
How soon do you expect a ruling?
Pardon?
How soon do you expect?
In fall this year, I think. Of course, then there's the possibility to go against this, and if they go to the highest court, there will be maybe 5 years if we have the last decision. But because of the many problems that Google is facing at the moment, and because of their first reaction to stop it this way, I'm quite sure if we have a first clear verdict, I'm quite sure that it will be the end. Of course, I can't guarantee it, but I'm very sure. Yes. What Google's lawyers were arguing was that the smartphone screen is too small to recognize what's on the thumbnails pictures is shown. And I'm quite sure anybody uses the smartphone and the picture search, you can at least recognize is the content of the thumbnails, one of the thumbnails, according to what you are looking for. And this is the only need for a search function. So I think when we go back and stay with the German or the Spanish version, it will be for the search function will be enough. So Google should accept that. One notion to other countries in the US, they are showing it the way that we are going against here in Germany. Because nowadays you can accuse or file a lawsuit against somebody all over the world when the violation is seen in your country. Then you can go to the courts of your country. So we might probably have the possibility to go against the usage of photographs on American screens. But we decided to do it the fast way, because if we went the other way, we would have to sue Google in the US, and let alone the sending of the letters and the pleas and going forth and back would take months. So and we decided just to concentrate on this decision on the smartphones in Germany, because we think this, the decision and the verdict of the court will make clear all the points that we want to hear of. So I think you will get the information from everywhere, because we will feed the media when we have reached our game. Thank you.
Thank you.
Yeah. Hello. Can you hear me? Yes. I hope so, at least. Yeah. Thanks to CEPIC for inviting me to talk a little bit about Google Images and antitrust implications I've been involved with. I filed a complaint against Google for a map provider, an internet map provider called Eurocities in Germany, which is known to use the domain Stadtplandienst.de. Some, at least of the German audience, may be used to that service. Although that's all I think I'm about to say about this complaint, because Michael Weber is going to talk about this map service provider complaint after me. So maybe I can fill in with anything you may find interesting from my part after Michael's presentation. But CEPIC has asked me to fill in with another favorite subject of mine besides antitrust, and that's copyright, and especially concerning the Svensson decision, and here what the Svensson decision means for Google Images, for copyright and for Google Images. So CJEU Svensson, I think it's important to mention to you as a non-lawyer, non-attorney audience, who is the CJEU? That's the Court of Justice of the European Union. Until the Lisbon Treaties some years ago, it was called ECJ. Maybe that's an expression that's more familiar to you. So it's the highest court in the European Union, and copyright-wise, as far as we are talking about European copyright law, it's the highest copyright court there is in the EU. So any ruling there is has a very high standing and has to be respected more or less by all the national copyright courts. That's why this decision is so important? The Swenson decision was about copyright protected text articles, and you may wonder why this is relevant for Google Images. At least the leading opinion would also apply all the findings there are on linking, on copyright and linking to text articles to linking to images. So, because in the end it's the same copyright issue, and it doesn't really matter if we're talking about text or if we're talking about pictures. So that's why this decision is also very relevant for all the linking that goes on in Google Images. What are the main findings of the Swenson decision? The basic finding, which is probably not really surprising, is any link you set to a legally published photo on the internet, which is freely available on the internet and has no technical restrictions for access of any kind, is copyright-wise irrelevant. So you don't have to ask for consent of the right owner of a photo, for example. If the photo is freely available on the internet, no technical restrictions to access it, also you can set a link, and copyright-wise it's like nothing has happened, because linking in such scenarios is copyright-wise free. What is important for Google Images, I think, is another saying in the ruling of the CJEU. The court has said that this freedom to link even applies in framing scenarios. Yeah? Even if you frame the content you link to and make the content appear as if it was your own content, that's copyright-wise free. No problem under copyright law. And so that obviously builds a certain defense for Google in Google Images. At least under copyright law, they wouldn't do anything illegal if they frame without asking the owners, the right owners of the picture. It is a different story if under antitrust law they behave illegally nevertheless, but from the copyright perspective, framing seems to be fine after the decision. And maybe I think that would be something for Dirk Feldman. My question to him is, if any framing is involved in his case, so maybe that could change the perspective the Hamburg court he is before has taken so far, or if the technology used by Google in his case is not framing, and so the case, kind of the Swenson case, doesn't really change your chances to win. But maybe that's for you can leave that for later. Maybe after my presentation, that would be one of my questions. Yeah, to finish with Swenson, I already mentioned linking is free whenever you have no technical restrictions to access a content, for example, a photo. So whenever you apply technical restrictions, links that circumvent these access restrictions make the linking illegal, or at least make them copyright relevant, so you need the consent of the owner. For example, you use session ID, which is a certain technical protection feature for against linking to content. If you circumvent that with a link, it would be a link where you would require consent of the right owner, or access code, same thing. What about linking to illegal stuff? So the general rule is that is a copyright violation, because linking kind of to illegal stuff enlarges the public and enlarges or intensifies the violation. So in general, a link to illegal content is illegal itself. It's copyright relevant. But usually good faith linkers that do not know that the content they link to is illegal would be exempted from liability. Yeah? The thing is that in these scenarios, Google and other search engines enjoy a further privilege as a search engine, especially Google Images would enjoy such a privilege. So in case Google links to an illegal photo, they are exempted from any liability in case the photo is also on the internet legally. Yeah? I cannot really explain you the reason why this is so, but that's the ruling of the German Federal Supreme Court in Vorschaubilder 2, thumbnails 2, you would probably translate it. It has something to do with implied consent. So the German Federal Supreme Court argued that there is implied consent for illegal photos in Google Images if you have legally kind of uploaded your photo elsewhere on the internet. Well, I think that's well, not really logic, I think, but well, it's five learned judges of the German Federal Supreme Court decided that way, and we have to live with it. So from the copyright perspective, to sum this up, I think you know, Google Images is a difficult target, especially when it comes to linking, because linking after the Swenson decision is generally a legal tool. That's why antitrust law is so important in this case, because even if Google does something legal, it may be illegal under antitrust law because it may be abusing Google's market power. Thank you.
Thank you. I'm rapidly going to move on to Michael Weber, as time is steadily being eaten up, and we have a session directly after this one.
Thank you, David. Who in the audience has heard of a California garage startup firm called Google? Please raise your hand. Okay, so clearly not a well-known company. Has anyone used one of these companies' products this week? No one, so clearly no dominant position whatsoever. You might as well stop speaking about it. So I guess no one here loves Google products either, or Google, if you don't even know the company, so I won't elaborate on that for now, but I'll get back to it in a minute. Both companies I represent are complainants in the EU antitrust investigation of Google. Also, HÖPPNER is a member of ICOMP. And CEPIC invited me today to show you which issues with Google the map and picture industries have in common. Maps are a visual medium just like pictures, and our industry's situation transformed about the same time as yours did, late 90s to 2000 years, from print to digital products. To give you an example, we were selling our company alone was selling 135,000 atlas books of the Berlin map per year, and this year maybe all of the printing companies, publishing companies are selling altogether 15,000 a year. So there was a massive decline in print product, and at the same time digital markets grew. HÖPPNER started taking printed maps in the late 90s and transforming them into online maps that are interactive and have the same look and feel as paper maps. So they're a little different than most of the online maps you know, but they are still very popular with many users because they like the way they look and how they work. We have a map website with maps worldwide since long before Google Maps. You just saw that in the slide before. And our business model is that web designers can license various hot maps and put them into their clients' websites to show any location. So we're similar to an online picture agency, and sometimes we even deal with the same buyers, art buyers and so on, or art directors that are looking for maps to visually enhance their websites. This here, for example, was a steakhouse chain that's all across Germany, and that was using hot maps to show where its restaurants are located. And a few years ago, they switched to free Google Maps. Ours cost them a little fee per map. And the steakhouse did save some euro for maps, but now Google knows that their website visitors are interested in having a steak, and Google can serve them competing ads for days and weeks to come, luring them into other businesses and restaurants. So why pay for a map or image if you think you can get it for free from Google? And that's pretty much the same challenge you face in the picture industry. A whole lot of the challenges are similar. Maps are very costly to produce. The development of websites and operation of them to properly showcase the maps for buyers to find them is a big operation, similar to a large image bank. Then we were challenged with piracy, many people preferring to steal a map rather than licensing one. The same happens to you with pictures all the time. Then there's the free ride mentality. Some companies did realize, and by now most have realized, that they do need to license a map, that it's copyright protected. But still they expect us to give them the maps for little or free, since they can steal them elsewhere or get them for free from Google Maps. Then there's the tying of Google Maps to search and Android more recently. Maps actually today in everyone's mindset are a part of Google, but they used to be a separate product and industry than search before Google tied them in with search, and we think that's illegal. Search manipulation is a problem because Google Maps, and that was part of our complaint also, Google Maps are always on top. If you're looking for a map, or maybe not even looking for a map, you will get a Google map on top of the search result page in a big, nice frame that other competitors can't even get. Then there's the issue of predatory pricing, predation. That means that maps we have to charge for to survive, Google cross-subsidizes and gives to web designers and website operators for free. That steakhouse I showed you earlier, they paid no money to install Google Maps on their pages, and now they're hooked on them. They invested some time in installing them on their page, and they're not so easily going to revert to using maps from someone else that they have to pay for. That's a similar mindset you're faced in the picture industry, where people are simply used to going to download pictures to Google Images and not get in touch with a proper picture agency or photographer. That led to an omnipresence of Google Maps, and even web designers that had a license to use our map, or companies, stopped using our maps because they weren't even aware they still had that license in their files, and started using Google Maps because it's so prevalent in their mindset. I wonder, where do 93% market share come from? And that's where I get back to my questions from the beginning. Some say Google is the best. Some say everybody loves using it. And I don't think that's true. Actually, most of these channels funnel users into Google's search results, and people aren't actively typing www.google.com every time, or DE, or whatever country they're in. They land at Google. It's rather a matter of contractual exclusive agreements with web browser makers, with big portals, with mobile device makers through Android, that funnel the millions of users into Google every day. Of course, many people know the brand and use it, but that's not the largest part of traffic, I claim. And I only call Google's search result pages so-called search result because most of what you see today is ads, Google's own products, and other things Google wants you to see rather than real search results. On this page, and I didn't need to fabricate it or look for it long, only the little green bit is an actual search result. Everything else is paid for or is a Google product. And Google Maps has had a hotspot on Google search result pages for quite a few years now, since about 2007. Meanwhile, Google Images is being blended with Google search results all the time, so it's very appealing to users to go there instead of to look for a proper picture agency or so on. And you would probably expect around here that these would lead you to photographers or picture agencies directly, but rather they lead to Google image search, and we've heard a lot about the problems with that today. And while the European Commission is kind of stuck in investigating only a few of the issues, Google has used the time to enlarge the placement of its own products. Again, this is comparable to the tactics where Google has upgraded its picture search to cause more competitive harm to the picture industry while the European Commission was busy dealing with other issues. And I'd like to say you're very lucky to have CEPIC and Freelance and people like Mr. Schilling filing lawsuits, filing complaints, doing the Brussels thing and fighting for your industry, because we mapping companies have to do most of that on our own. So to finish my presentation, I'd just like to give Freelance and CEPIC a hand, and I hope you'll join in.
Thank you, Michael. Time is pressing on. It's the turn of Kathy Aaron.
Okay, I know we're almost out of time, so I will be brief. I'm to talk about America's perspective on the whole Google issue. And when Sylvie first called me about the EU's investigation and action against Google, I was thrilled, because unfortunately in America, our hands are pretty tied about how we can approach Google and what we can do in the courts against them. Ever since the case back in 2007, which was called the Perfect 10 case, and it was brought up in the 9th District Court, and it's where Google was brought to task about the use of images on their search engine. And in that case, the 9th District Court decided that the framing of images and the use of images on their search engine was fair use. And that pretty much changed the whole horizon in the courts for bringing suits against Google. And since then, there have not been any cases against Google in court having to do with the internet. So we in America were thrilled to be able to join in this EU case, and we're very hopeful that there will be a positive outcome so that hopefully we can put some kind of pressure in America on Congress and the Copyright Office to try to bring some kind of suits against Google. Google's kind of lived a really great existence in America since that case in 2007. A lot of people feel that they pretty much own Congress. There have been a lot of different issues brought to the attention of Congress about the dominance of Google, things such as the manipulation of the search results, especially since January of last year, the use of other people's intellectual property, antitrust, monopoly, and the restraint of trade. And we haven't been able to get Congress to do anything or help us bring any kind of suits or legal action or any kind of pressure from Congress at all against Google. And those of us who are represented by legal entities feel the frustrations as well. We ran a survey, I believe it was the end of last year, to our members of PACA, and we were getting comments such as 55% in the drop of traffic to their websites, 1/5 drop of traffic to their websites, half drop traffic to their websites, 50 to 70% drop in traffic to their websites. So in America, we're feeling some of the same effects from the new search engine changes that Google made as well. Google's answer in America is that their focus is not on traffic to websites, but the user's experience, and that their search changes improve the experience to the user. I don't know how you answer that when you have a company that big whose focus is not to business. So my first meeting to ICOMP was April of this year, and it was such a relief to be in a room of people who were all voicing the same concerns, and hearing people from other countries who are actually in a place to file suit and take action against Google. So I was thrilled that Sylvie asked me and persuaded me to join ICOMP, and PACA is now a member, and that she asked me to come today to give the American perspective. But unfortunately, I can't bring good news because we really aren't doing anything actively like the EU is doing at this point. So other than being very supportive of what's going on in Europe, we are kind of sitting around and waiting to see what happens here, and hopefully then we'll be able to make some positive movement over in America. We are right now, especially Nancy Wolf, our attorney, has been asked to speak almost monthly in front of the Copyright Office. And the Copyright Office is very active in making presentations to Congress about how important copyright protection is. And hopefully maybe through those actions we will see some movement. But right now, Google is kind of getting a free ride in America. So it's not great news. But like I said, hopefully with what's happening here, we'll be able to get some good news over in America. Thank you.
Well, I promised you some time for discussion and engagement, but we've run out of time, and it wouldn't be fair on the next speaker.